Hi everyone, welcome to the community classroom. Now that we have the Freudian minutes started, we are also going to begin our series known as the Mini Law School. And so for this discussion, we are going to be looking at the psychology of law. And we're going to be looking very specifically at a particular court decision that was based upon what's known as legal error. Now we're going to be looking at the doctrine of discovery specifically and focusing on the McIntosh case. So we're going to be looking at dynamics of choice of law, jurisdiction. We're also going to be looking at this issue of legal fallacy that's embedded in the doctrine of discovery and the McIntosh case. And this legal fallacy led to legal error. We're going to be also looking at superseding law and relief from error. We're also going to be considering all of this in the context of what is actually lawlessness. And so there is an element of psychopathy running through this entire legal historical dynamic. And so there's a big piece of deception going on that has led to this legal error. And so we're going to very quickly look at all of these things. So to get started, we're just going to look at some foundational dynamics related to law. Now, if you look up this construct of law, it's going to take you to the Old Norse and the Old English, and it's going to lead you to the idea that law essentially means set. What else would it mean? Of course. But this construct of law, this word, it is older than the Old Norse and the Old English, and you can see it rooted in the Latin, you can see it rooted in the Hebrew. And as we've discussed before, law is coming out of this construct of Leviticus. And so you see these interchanges with respect to these letters. You can see law with the LAW. That W can be replaced by the U. That U can be replaced by the V, depending on what time in history you're talking about. You also see where the A and the E are interchanged, and you get these constructs that tie law and Leviticus together. And here you can see very clearly that Leviticus is about a book of laws. Various laws, but laws nonetheless. And so you have the laws related to the priesthood, you have these laws related to the people and this idea of holiness, you have these laws related to ceremony. And so essentially, Leviticus is a book of laws. And so law and Levite and Levitical, all of those constructs are actually tied together. Now let's get into this doctrine of discovery. And of course, we've examined the doctrine of discovery before, but we're going to look at it from a strictly legal angle, looking at the forensics. In other words, we're going to be looking at the psychology of this law. Now, what's interesting is what's really going on with respect to the doctrines is a doctrine known as the doctrine of conquest. However, the court thought it was prudent to focus on this doctrine of discovery. And so we are going to follow along based upon this doctrine of discovery. We're going to look at the root of the doctrine of discovery. It's important to keep in mind that all law is founded upon psychology. Do not forget that. All law is founded upon psychology. So there's a psychological underpinning to all law because, of course, law is about the regulation of behavior, the regulation of human interactions. And so with respect to this doctrine of discovery, we have a number of psychological underpinnings. And so first of all, we have the behavior. And remember, psychology is about behavior and the cognitive and emotional underpinnings of behavior. And so with respect to the doctrine of discovery, in this case, the behavior we have is the holding. And so that's the decision of the court. And then the rationale that was given for this holding. And so with the holding, you have the cognitive dynamics that are underpinning the behavior. And then there are some emotional dynamics that are underpinning the behavior, that holding, with respect to Marshall in particular. And so there are cognitive dynamics, and the cognitive dynamics that are under this doctrine of discovery. These cognitive dynamics are rooted in bias, fallacy, and error. There's also an emotional component that is playing a part in this case, in this doctrine of discovery. That emotional component with respect to Marshall, Justice Marshall, there is a fear related to the outcome. And so that fear, coupled with the cognitive bias and the cognitive fallacies, all of these things play into this ultimate holding that we have. So now that we have these psychological constructs, let's look at the legal dynamics related to this case. One of the most interesting parts of this case involves the choice of law. It's a very odd dynamic. In this particular court case, we have a court that decides to reach out to ecclesiastical law and pull it into the proceeding in order to come up with this doctrine of discovery outcome. And so the court decides to use as a ruling authority ecclesiastical law. And there's the assertion that this ecclesiastical law is international law. And ecclesiastical law is basically church law. It could be Levitical law, but specifically what the court did was it reached out to those papal bulls. And the papal bulls are based upon ecclesiastical law. So there is an assertion of church law. Not only is there the assertion of ecclesiastical law, there is the assertion that it is New Testament law. And so essentially they invoked Jesus in this entire paradigm. And so they are basically saying this is all based upon Jesus. This is all based upon divine will. And so this is what the court is essentially saying. And so the court is subordinating what you would consider to be civil law or secular law. It's subordinating it under ecclesiastical law. It's important to keep in mind, however, that U.S. law grows out of the books of Leviticus and Deuteronomy. Yes. And so there is this invoking of the ecclesiastical law in order to come up with this determination. And this is important for a number of reasons, because the law now is under this ecclesiastical foundation. And interestingly, it is this invocation of church or Bible law, whether we're talking about Old Testament or New Testament, this is the very thing that turns the doctrine of discovery on its head. So when the court looked at this case, this McIntosh case, what it did was it pulled into the legal reasoning these 15th century papal bulls. And so it pulled in these papal bulls in order to justify the taking dynamic that took place with all of the colonizations that went on around the world, and specifically here in the Americas. And so the papal bulls were invoked. And when the papal bulls were invoked, something very special took place. What the Supreme Court was basically saying was that this was essentially supreme law, the ecclesiastical law coming from these papal bulls. Well, this is very interesting because there was another dynamic that was operating that was not mentioned in the holding of this particular case. And so now we're going to direct our attention to the legal error in the case. Now, there are two types of error that can occur in a legal proceeding. One error is related to fact. And so, of course, this would be related to the jury, and the jury is generally the finder of facts. And so we have error related to something that's factual. And there are implications related to that. But then there's the more serious error, which is legal error. And when we have legal error, there's a mistake about the law. And in this doctrine of discovery case, there is a major mistake about the law based upon this odd choice of laws. And when you have an error in terms of the law, you are operating in legal fallacy. And legal fallacy is going to result in error related to legal reasoning. And that error is going to relate to the legal holding. And so there's a lot of error going on. But what you also have with respect to legal fallacy and legal reasoning, those are psychological dynamics. And so this goes to cognition. This goes to distortion. And so this is the psychology that is operating in relation to the doctrine of discovery in this Marshall case. There are cognitive problems in the legal reasoning process. And here you can see the information related to the two types of error. And remember, we are focusing on the mistake of law. And so it indicates here, in general, an error is a mistake or a misconception. And that's what we have with the doctrine of discovery. And this is prior to the 2023 papal bull that was released. And it indicates here, in legal context, an error is either a mistake of fact or a mistake of law. In general, a mistake of law will nullify or reverse a judgment in the case. This is very important. Hold on to this because this is going to relate to what we're going to be looking at with respect to this specific legal error with the doctrine of discovery and this McIntosh case. It can be argued that the McIntosh case, the doctrine of discovery, that it could have been nullified at its very inception in terms of this court case. And the reason why is that there was what is known as superseding law. Okay, so there is this choice of law, this choice of ecclesiastical law, and that's what the court used for this doctrine of discovery. However, the law or the doctrine that was used had already been superseded. In addition to this superseding international law, there is also another dynamic that took place with respect to this Marshall court, this McIntosh case. In the law, in legal proceedings, attorneys have an obligation to reveal adverse legal authority. And so let's say, for instance, you are representing a client and in your research, you find some law that is in opposition to your client's position, but it is authoritative. And so when you see that, you have an obligation to let the court know that there is some law that is adverse to your client's position and it is authoritative. And this is a part of what's known as the duty of candor toward the tribunal. Okay, so in this Marshall case, in this McIntosh case, in this doctrine of discovery case, we have some adverse legal authority based upon the ecclesiastical law that was not provided to the court. And so there was already something that overturned dum diversus, for instance. There was something that already overturned this. And the court decided to ignore it. Not only did the court ignore it, but King James founded those charters on ecclesiastical doctrine too. So he reached out to these doctrine of discovery papal bulls, and he used this to support his position when he decided to issue these charters and engage in this colonization. And so based upon his position as the monarch, it's very clear that he was not only aware of the doctrine of discovery papal bulls, but undoubtedly he was aware of the superseding papal bull that came after them. Not only was he aware, and perhaps he wasn't aware, but there's also something in law called constructive knowledge. And so the law was out there. There is the assumption that he had the knowledge. He might not have had actual knowledge, but we are all generally held to constructive knowledge. And so he had the ability to become aware of this superseding law related to the doctrine of discovery. He decided, however, apparently to ignore that because he wanted something, and that superseding decision was ignored, and it allowed for an outcome that he wanted. And so you see the same thing in the McIntosh case. There is an ignoring of the superseding legal authority, and that allowed for this decision, this McIntosh decision, this doctrine of discovery decision. And so we're going to look at this superseding legal authority. Not only do the parties have an obligation to the tribunal to advise the tribunal of legal authority, adverse legal authority, the court also, in publishing its opinion, engages in legal research. And so the court itself, Marshall, should have uncovered and addressed the fact that there was superseding legal authority that went beyond the doctrine of discovery. The superseding legal authority came in the 16th century, actually not that long after the doctrine of discovery was put forth in terms of the Dum Diversus and the other papal bulls that came out in the 1400s. And so in the 16th century, we have an international overturner. In other words, it is the doctrine that supplanted the doctrine of discovery. And the name of this papal bull is Sublimis Deus. Sublimis Deus essentially means God is supreme or God is exalted. And so it is indicating that to all of these so-called Christian princes that God is supreme over them in terms of this doctrine of discovery dynamic that has been going on. And so this is another papal bull that came out nullifying the doctrine of discovery, and it is addressed to the Christian community. And so again, you have this dynamic of constructive knowledge, even if the monarchs didn't have actual knowledge. It is the possibility that these monarchs did not have actual knowledge is slim to none. Okay, so we have Sublimis Deus here, and Sublimis Deus is on the enslavement and evangelization of Indians. This is from Pope Paul III, and this is coming out in 1537. And here we can see very clearly the addressee of this particular papal bull. And so the Pope is indicating that this is to all faithful Christians to whom this writing may come. And so the Pope is indicating that this is supposed to be going to all of these faithful Christians, and very specifically, it would be going to the monarchs, because remember, the doctrine of discovery, it's rooted in that whole idea of these Christian princes being able to take authority over these discovered lands. And so this particular papal bull is really addressed to those entities and to other clergy, related to this entire dynamic of the doctrine of discovery. And so this Pope is invoking a number of things in sending out this particular document. And one thing in particular is that the Pope is invoking the supremacy of God in the New Testament. And so this message undoubtedly went to King James. He had awareness of this particular papal bull. The monarchs in the area that would have been under the papal bulls in the first place, the doctrine of discovery, they all would have awareness of this particular papal bull, and they would have awareness of the implications of this particular papal bull. This is particularly important with respect to King James, because when he initiated these charters, they were founded upon the earlier papal bulls. And there is a complete ignoring of the fact that the papal bulls have been nullified. And so we're going to look at the exact language of Sublimis Deus so that we can get a better understanding of the authority of this particular papal bull and how it supplanted the doctrine of discovery. So we're going to go down to the bottom so we can get to the heart of the matter. And this Pope indicates, notwithstanding whatever may have been or may be said to the contrary, the said Indians and all other people who may later be discovered by who? Christians, are by no means to be deprived of their liberty or the possession of their property, even though they be outside of the faith of Jesus Christ, and that they may and should freely and legitimately enjoy their liberty and the possession of their property, nor should they be in any way enslaved. Should the contrary happen, it shall be null and have no effect. So not only do we have this superseding legal authority in this papal bull, we have no subsequent overturning of Sublimis Deus. We have no papal bull that speaks to Sublimis Deus in order to overturn it. And so therefore it stands. Now, of course, this is interesting because, again, there was this choice of law, and the choice of law was ecclesiastical law, Roman church law, and then we have the Roman church law being overturned and the court ignoring the fact that this has been overturned. But of course, there is the insinuation that Marshall had a vested interest in the outcome, and so therefore that tainted the way the court process went in that McIntosh case. But what we have with this nullification is the nullification of the Virginia Charter. And so when the Pope is indicating that this is going out to all of these relevant Christians, these Christian princes, the Pope is basically saying, if you do anything contrary to this, if you continue to follow the doctrine of discovery, whatever it is that you do based upon that, related to the Indians, is going to be null and void. There's also an interesting insinuation in this particular papal bull that the Indians are not just the Indians that are west of Rome, but apparently there are some Indians that are south of Rome. And so it would be interesting to get a handle on whether we are talking about Indians that are south and west, or whether we are talking about Indians that are south and Indians that are west. And interestingly, because King James chose this particular law also, he decided to use Roman church law in coming up with the foundation of these charters. And so the charters are also based upon overturned law. Now, of course, it's impossible to know exactly how the McIntosh case would have come down had there not been the inclusion of or the submission to this ecclesiastical law. But what we have right now is what I've decided to term the McIntosh error. The McIntosh error is not based upon controlling legal authority, which is sublimis deus, according to the court's choice of laws. And also, when you look at King James again, he is not bringing himself under submission of sublimis deus, although he asserts that this is all based upon the initial papal bulls for the doctrine of discovery. He just conveniently ignores that this whole thing has been overturned. And then many, many years later, the McIntosh case decides to also ignore the fact that this doctrine of discovery is null and void. And so it's been null and void since the 1500s. And so the controlling legal authority was not those papal bulls. It was sublimis deus. This was ignored. This is what we consider legal error, no doubt. If there had been some other invocation, perhaps, we might be able to look at that. But there really is this dependency on the doctrine of discovery and the Pope basically giving the land to Portugal and Spain, and then also giving it to any other Christian princes that might find it. And of course, no doubt, King James is considered a Christian prince. He's, supreme among the Christian princes. And so here this supreme Christian prince decides to pretend that sublimis deus does not exist. Now, of course, you should be wondering, what is the potential relief related to this Macintosh error. So let's look at relief related to legal error. What traditionally is available when there is legal error? Now, the reason why this case and all of these dynamics are very difficult to navigate is that psychopathy element that is a part of all of this. Apparently, you have to have some psychopathic stuff going on here in order to initiate this foolishness and to pull it off. And so therefore it makes it very difficult to navigate around it because of the level of deception that individuals who operate in psychopathy tend to employ. And so there's a lot of deception going on. When you look at the treaty making processes, there's so much deception going on. And so it's very difficult for the average person, the normal human being, to really navigate around all of the foolishness. And so therefore, people might not even dig any deeper because there are all of these layers of foolishness. It's very difficult, if you look at any of the treaties, to really make sense of the treaties. Not just the treaties in terms of the language of the treaties, but the processes involved in the treaty making. There was significant deception involved in the treaty making. Sometimes, for instance, you didn't even have two different parties negotiating these purported treaties. Often you had an individual who was playing two sides against the middle. And so therefore, the person on one side of the treaty was basically essentially the person on the other side of the treaty. And so they were essentially making treaties with themselves. It was a very interesting process. And also suggesting to the indigenous people that the executive authority was their father. So it's very interesting when you read this foolishness, but that's what was put out there. So there's a lot of deception going on with respect to the charters, with respect to the treaty making. Even when you look at the start of the colonies and how the colonists, the settlers, were deceived into coming in the first place, and how they got all of the people out of Western Europe into the United States in the first place. The whole process was just filled with deception, including things like the Highland clearances and similar dynamics. And so there's just so many layers with respect to deception that make it very difficult, again, to navigate around all of this foolishness. And so here we have the Macintosh error. Now we're going to look at what are options in terms of relief that you would traditionally see in a legal case that involved legal error. Now, with respect to the federal courts, we have what is known as relief from a judgment or order. We have what are known as federal rules of civil procedure. We also have rules of civil procedure at the state level. And so each state will have its own rules of civil procedure. The states also have their own rules of criminal procedure. And within the federal rules of civil procedure, we have what is known as relief from a judgment or order. And this is related to legal error. So in theory, there is the option or the possibility of relief from Macintosh. There is the possibility of relief from this doctrine of discovery. There is the possibility, and note that I said possibility, of this being considered legal error that requires a remedy. I want you to, however, keep in mind the reality of the situation. And so it's important to engage in adequate reality testing. And so what's the reality of the situation? What are we really dealing with here? And even though there is the possibility of relief from Macintosh, and there is the possibility of relief from the doctrine of discovery, the question is there a probability of that occurring? And it's important to keep in mind the spirit and the psychology underpinning the doctrine of discovery and the Macintosh case. What is underpinning the doctrine of discovery? What's underpinning those papal bulls? The underpinning is psychopathy. You see the deception. You see the grandiosity. You see the duping delight that has been integral to these processes. And even though typically there is relief available, one has to do adequate reality testing and look at the entire situation and the implications of relief. And this will give you an idea of whether relief is actually probable. Relief is possible. Anything's possible. However, it doesn't seem probable. And I'm going to leave you to think about why it's not probable, even though, in the interest of justice, there should be the nullification. However, there are some other dynamics at play. And if you nullify the doctrine of discovery and you nullify the charters, you nullify a number of other dynamics. And I want you to think about whether it is probable that any court anywhere would nullify the doctrine of discovery, would nullify the Macintosh case, even though there is blatant legal error and perhaps fraud upon the tribunal. And so when looking at the relief that is available, we see that there can be relief from a final judgment, order, or proceeding based upon mistake, and also based upon fraud or misrepresentation or misconduct by an opposing party. This would also include fraud, misrepresentation, and misconduct by the tribunal itself. In fact, the court doesn't even really need fraud in order to have grounds for relief. It can be based upon, as it indicates here, any other reason that justifies relief. Now, of course, the situation that we are dealing with respect to the doctrine of discovery, this is a very old dynamic that we are dealing with. But in general terms, there are time limits related to filing motions for relief. However, this is a very special situation, and so it would be very interesting to see what might be possible with respect to this particular type of legal error. Again, we are talking about possibility and not probability, because there is very little probability that the court, even on its own accord, would take this situation up. However, if looking at the law in its strictest terms, what we see is a legal error with severe consequences, and a legal error that is founded upon fraud upon the tribunal. The reason why we have this fraud upon the tribunal is we have these parties. Neither party brings up sublimis deus. And the court, in its own research, also decided to overlook sublimis deus and go back to the papal bulls of the 1400s to come up with this very serious determination. Hopefully, you are better able to understand the psychology of the doctrine of discovery and the psychology underpinning the law that became this Macintosh case. And hopefully you are able to start considering the implications. Hopefully you better understand this whole idea of superseding law and you see how it applies to this case. Hopefully you are also able to do some significant reality testing in terms of what is possible in terms of relief for the parties that are involved. And indeed, with respect to the Macintosh case, there were individuals and collectives of individuals that have suffered because of this decision that were not parties to this original decision. And so there's a lot to think about, but I want you to think primarily about the dynamics of legal reasoning, the dynamics of legal fallacy, resulting in legal error in this particular case.